Good day, ma'am. This is Mercy Deline. Our report is all about extinguishment of obligations under the special forms of payment. Applications of payment, dation in payment, payment by session, tender of payment, and consignation. Under the subsection 1, application of payments for Article 1252. He who has various debts of the same kind in favor of one of the same creditor may declare at the time of making the payment to which of them same must be applied, unless the parties so stipulate, or when the application of payment is made by the party whose benefit the term has been constituted. Application shall not be made as to debts which are not yet due. If the debtor accepts from the creditor a receipt in which of an application the payment is made, the former cannot complain of the same unless there is a cause for invalidating the contract. Meaning of applications of payments. Now, application is the designation of debt to which should be applied the payment by the debtor who has various debts of the same kind in favor of one and the same creditor. The requisites of application payments are there must be one debtor and one creditor. There must be two or more debts of the same kind. All of debts must be due, and the amount paid by the debtor must not be sufficient to cover the total amount of the all debts. Under the Article 1253, if the debt produces interest, payment of the principal shall not be deemed to have been made until the interest have been covered. And another is the Article 1254, when the payment cannot be applied in accordance with the preceding rules, or the application cannot be inferred from other circumstances, the debt which is not most onerous to the debtor among those due shall be deemed have been satisfied. If debts due are the same nature and burden, the payment shall be applied to all the proportionately. And for the subsection 2, payment by cession, under the Article 1255, the debtor may cede or assign his property to his creditors in payment of his debts. This cession, unless there is a stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned. The agreements which, on the effect of the cession, are made between the debtor and his creditors and governed by special laws. Payment by cession is another special form of payment. It is the assignment or abandonment of all the properties of the debtor for the benefit of his creditors in order that the latter shall sell the same and apply the proceeds thereof to satisfaction of the creditors of their credits. Requisites of payment by cession. There must be two or more creditors. The debtor must be partially insolvent. There must be an acceptance by cession by the creditor. Subsection 3, tender of payment and consignation, under the Article 1252, if the creditor to whom tendered of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Consignation alone shall produce the same effect in the following cases: when the debtor is absent or unknown or does not appear at the place of payment, when he is incapacitated to receive the payment at the time it is due, when without just cause he refuses to give a receipt, when two or more persons claim the same right to collect, when the title of the obligation has been lost. Tender of payment is the definitive act of offering the creditor is due him or her together with the demand that the creditor accept the same. For consignation is the act of depositing the due with the court of judicial authorities whenever the creditor cannot accept or refuses to accept payment and generally requires a prior tender of payment. No, tender is the antecedent of consignation that is an act preparatory to the consignation, which is principal and from which are derived the immediate consequences which the debtor desires or seeks to obtain. Tender of payment may be extrajudicial, while consignation is necessarily judicial. Under the Article 1257, in order that the consignation of thing due may release the obligor, it must first be announced to the person's interest in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly consonance with the provision which regulate the payment. Under the Article 1258, consignation shall be made by depositing the things due to disposal of the judicial authority before whom the tender of payment shall be proved in a proper case, and the announcement of the consignation in other cases, the consignation having been made, the party shall be also notified thereof. The rationale for consignation is to avoid the performance of obligation becoming more onerous to the debtor by reason of causes not imputable to him. Other article is the under Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. The general rule is that the creditor will bear the expenses of consignation because consignation of the obligation had been made because the creditor whom tendered of payment was made to refuse to accept it is without just cause. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation before the creditor has accepted the consignation or before the judicial declaration that the consignation has been properly made. The debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preferences which he may have over thing. The co-debtors, guarantors, and sureties shall be released. Section 2. Loss of the thing due. Under Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if should be lost or destroyed without the fault of the debtor, and before he has incurred in delay, when by law or stipulation the obligor is liable even if the fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. General rule: the obligation to deliver a determinate thing is extinguished if it should be lost or destroyed. Requisites in order that the obligation to give determined thing will be extinguished. The obligation is to deliver a determinate thing. The thing is lost without the fault of debtor, and the thing is lost before the debtor has incurred in delay. The other exceptions are when the law is so provides, when the stipulation so provides, when the nature of obligation requires the assumption of risk, when the loss of the things occurs when the fault of the debtor. Under the Article 1263, in an obligation to deliver a generic thing, the loss of destruction of anything of the same kind does not extinguish the obligation. Under the Article 1264, the court shall determine whether, under the circumstances, the partial loss of the object of the obligation is important as to extinguish the obligation. Um, and next is the Article 1265. Whenever the thing is lost, the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. That is all about our report. Thank you.
Article 1266. The debtor and obligation to do shall also be released when the possession becomes legally or physically impossible without the fault of the obligor. Article 1267. When the service has become so difficult to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. Article 1268. When the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause of the loss, unless the thing having been offered by him to the person who should receive it, the latter refuse without justification to accept it. Article 1269. The obligation having been extinguished by the loss of the thing, the debtor shall have all the rights of action which the debtor may have against third person by reason of the loss. Section 3. Or condonation or remission of debt. Article 1270. Condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. One and the other kind shall be subject to the rules when governed and officious donations. Express condonation shall furthermore comply with the forms of donation. Article 1071. The delivery of private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver, it should be named to inofficious, the debtor and hers may uphold it by proving the delivery of the document was made in virtue of payment of the debt. Article 1072. Whenever the private document in which the debt appears is found in the possession of debtor, shall be presumed that the creditor delivered it voluntarily unless the contrary is proved. Article 1273. The renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Article 1074. It is presumed that the accessory obligation of less has been remitted when the thing lends, after its delivery to the creditor, is found in the possession of the debtor or of a third person who owns the thing. Section 4. Fusion or merger of rights. Article 1075. The obligation is extinguished from the time of authors, creditor, and debtor are merged in the same person. Article 1076. Merger which takes place in the person of the principal debtor or creditor benefits the guarantors. Fusion which takes place in the person of any of the latter does not extinguish the obligation. Article 1277. Fusion does not extinguish a joint obligation except as regards the share or spending of the debtor of or debtor in whom the two actors concur.
Tapos na.